we can start off with quick introductions with everyone who's here. And then after that point, we'll kind of let you go into it and more people might come in as we go. But I'll get started. So I am Rachel Adams, and I am the marketing and events coordinator here at Startup Zone. So I'm really excited for this today. We've done a lot of marketing and branding workshops recently, but we haven't really dug into the legal side of that, which a lot of people don't understand, myself included. So I'm very excited to learn a bit more about it. I see Redden's in here, but I also see him in the Startup Zone doing some other things. So maybe Jackie, we'll skip over to you. No, maybe not. Jolt, oh, there you are.
There's a delay. There must be a delay a little bit. Am I just introducing myself? Is that what you're asking me? I'm still trying to figure out how to get my screen changed here too. Sorry.
That's okay.
We
kind of start small off. Yep, go for it.
This is rural internet for you. I run a winery, brewery, and distillery tour operation. So I'm really interested in this actually because a couple people have made light to me that someone else is using the same name as me, sort of. It's close enough that I should probably consider doing something about it. So this is a good timing for me to sit in and listen to this actually. So it's good.
Awesome, sweet. Well, thanks for coming out, Jackie. Jolt Winnie, I'm so sorry about the pronunciation of that.
It's fine. Hi, everybody. My name is Jules Winnie, but you can call me Jules for short. Hello? Okay, good.
Hey.
I am a student at UPEI, and I'm just interested in all things business for right now, trying to gain as much knowledge as I possibly can for the near future, for whatever it is that I come up with or whatever. So I just wanted to get as much knowledge as I possibly could.
Awesome. Well, thanks for coming out. And I know we did have a few more people I saw on the list earlier that I'm expecting to come out. But yeah, Donna, if you just want to keep an eye down on the bottom there, they should pop up on that participants bar. Otherwise, we're good to get going whenever you are.
Yeah, I've got one person that needs to come in, but for some reason, I can't get her in. It's Erin Robar.
Okay, yeah, Erin's the operations manager here. Sometimes when you hit admit, it does take a sec for them to come in. Is the admit option there?
No, I'm just clicking on the, see, you really needing controls. This is what happens when you give it to the old ladies.
Well,
and admit all. So, Justin.
Oh, there we go. I see more people coming in now. Yeah, it's a totally new feature. They changed up like last week. There we see more people coming in. Yeah, I used to be able to control it the whole time, but now only the person screen sharing can control it. So if any more questions pop up, feel free to just ask me throughout. I'll be here. But otherwise, I think we're all good to go.
Okay. So my name is Donna MacEwan. I am one of the partners up the Charlottetown office of McInnes Cooper. McInnes Cooper is a regional law firm. I specialize in intellectual property matters, and I also do general commercial and insurance litigation. But I've been a registered trademark agent in Canada since 1991, so that'll give everybody a hint as to my age. So today, how I thought that we would do it, Rachel and I had some discussions. So we've got an hour, but what I'd like to do is to present this PowerPoint to you on Trademarks Basics, much like I would in the initial discussion with a client or potential client who wants trademark protection. It's not going to be long. It's going to cover the basics because we wanted to leave a significant amount of time for people to ask questions. So feel free to ask questions verbally or you can write notes. But I'm just going to get started here. So very generally speaking, a trademark is one of the types of intellectual property that there are. And so the reason for this slide is you'll often have quite a few people who don't understand the different types. So they often think that they need a trademark when in fact they need copyright protection, or they want a patent when really what they're looking for is a trademark. So I'm just going to take a minute to talk about the different intellectual property rights so that everybody understands the difference on a very basic level. So we have trademarks, which we're going to talk about today, and trademarks are basically your brand in the simplest of terms. We're going to talk about the definition of exactly what a trademark is next, but there's other types of IP rights. So there's copyright, and copyright protects what's called legally works. So artistic works, paintings, sculptures, literary works, books, poems, ebooks, and all the rights that go along with that. It protects musical works. It protects most of the arts type of developments are protected by copyright. And back in the day, Parliament thought that when computer programs were developed initially, Parliament, in its wisdom or lack thereof, thought that the best form of protection for computer programs was copyright. So computer programs was listed as a work in the Copyright Act to be protected by copyright. And there's been ongoing litigation over the years where people want their computer programs to be protected by patents, not copyright, so they try and sneak it in through the patent office, but that's a whole other presentation. So you have copyright, you have patents. So patents protect inventions, quite simply, new and unique inventions. Industrial designs are a unique IP right, not often used. So what's happening with industrial designs is they simply protect the aesthetic features of a manufactured article. So its shape, if it's got, a nice curly Q on the surface. So industrial designs are not meant to protect anything that's functional, only the aesthetics or the shape of things. So for those of you who read the tech news, it was industrial designs that was the subject matter of a large lawsuit between Apple and Samsung in terms of the shape of the phones. And so finally, in the important IP rights are trade secrets. So that's where people protect their intellectual property. Most often, that's recipes or processes by keeping it a secret. And people often do that because they don't want the limited rights of a patent, which is only 20 years. So they protect it contractually. The most famous trade secrets are very long-standing. They would be the KFC chicken recipe and the Coca-Cola recipe. So those are the types of IP rights. We're going to talk about trademarks today. This is a trademark. It's the Startup Zone's trademark. It's comprised of words and designs to form a logo, and that in itself is protectable. And also, just the words without any font or design, Startup Zone, also constitute a trademark. So in terms of defining what a trademark is, the Trademarks Act has recently been amended for the first time in over 100 years, so that the definition of a trademark has expanded to include sound. But most people, their trademark or their brand is comprised of a word or a word and a design. They've got numerous trademarks even around the same concept like we were just talking about with Startup Zone. Sound is now trademarkable. I have yet to have a client who wants to trademark a sound, but apparently there are those that have been applied for that are jingles, or a distinguishing guise, which is just a fancy way of saying your getup or your packaging that of the goods and services that you use the trademark for. So for example, you know, if you have specific packaging and colors, like you'd see, for example, on a Dove soap, then that is part of what is trademarkable as well. So the key here is that your brand is either one of these things, a word, a logo, a sound, that you use in association with your goods and services for the purpose of distinguishing your goods and services from others. So that when people go to buy a pair of Levi's jeans, they see the red Levi's tag on the pocket and they immediately know the source. They know whose those jeans are. And so that's part of use of a trademark. So, and it's the important part because you want everybody to know. For example, when you see the golden arches or you see the words McDonald's, McDonald's wants you to think of McDonald's Corporation. So that's basically what a trademark is. The most important concept around trademarks is that you use it. So there's two types of trademarks. There's unregistered trademarks, which we call common law trademarks. So, you know, you've been using your brand for a while, you've been using it in association with a product and a service, and, you know, you haven't registered it, but, you know, you advertise it, it's on your labels for your products or on tags for your products, and, you know, you've been using it for a while. You have acquired, you know, rights in that brand and in that trademark. Those rights are a little different from a registered trademark if you registered it, but basically your rights extend out to the geographical area in which you've built up a goodwill or reputation. So let's use the Startup Zone trademark as an example. So the Startup Zone provides services to startup companies, you know, that assist them in getting off the ground and improving their business. They do this in the city of Charlottetown. Let's say, hypothetically, they are known in Queens County. And so let's say someone in Quebec starts up the Quebec Startup Zone. The PEI Startup Zone could not enforce its unregistered trademark against the Quebec Startup Zone because they only have a reputation or goodwill in Queens County, Prince Edward Island. So that's the only place they can enforce it, okay? The other thing with common law rights is you can enforce them in this geographical area in which you built up a goodwill, and if it's known throughout PEI, then you can enforce it through a PEI. But, you know, it's also harder to enforce a common law trademark than it is a registered trademark. You know, what you have to establish is just greater. You know, you have to establish by evidence that, you know, goodwill or reputation and exactly where it extends to. You have to establish that the other party misrepresented their goods and services as yours for the most part, and that you've suffered a loss, that you actually have damages arising out of this. So then we go on to the next type of trademark. It's a registered trademark. And, you know, the big benefit of registering your trademark is that it is enforceable Canada-wide, regardless of where you're using it. So as long as you're using it in association with the products and services in your registration, it's enforceable Canada-wide. It's good for 10 years, but it's renewable indefinitely. So you just every 10 years, you have to pay the federal government some more money, a renewal fee, and then you're good for another 10 years. You have to continue to use it, and we'll talk about use a little later in more detail, but you have to continue to use it to be able to enforce it. Use is the most important aspect of a trademark, whether it's registered or unregistered. So again, the benefits, you've got national protection. So that broadens your protection for your trademark. And it's also easier to enforce it because all you have to do is establish that the alleged infringer has a confusingly similar trademark to yours. You don't have to show any misrepresentation. And you have a choice. You can either sue them for the damages you've suffered as a result of their infringing use, or you can seek the profits that they gained as a result of using your trademark. So we're going to talk a bit about timelines a little later on, but very generally speaking, from start to finish, it takes now over 2.5 years to go from trademark application to trademark registration, and that's assuming no opposition proceedings, which we'll talk about as well. Your cost is about $2,500 to $3,500 over that 2.5 year period. So that's your overall general costs. It includes the legal costs, and it includes the government fees, although it may be a little higher because now we have government fees that depend on the number of classes that your goods and services fall into. So, you know, that can be up or down by a couple of $100. So your initial costs to prepare and file the application is $1,000 in legal fees, plus your government filing fees, which are $330 for the first class of goods and services that your goods and services fall into, and then $100 for each additional class. Now, when I say that initial amount, that's included in the overall estimate of $2,500 to $3,500. So we'll go through this in a practical way, but you know, you've developed a new brand, or you've been using your brand and you want to either register it or enforce it against others. So the question becomes, what do you do? So I always say to people, this is when you should do some due diligence, whether you've got a new brand or one is relatively new in terms of your use and it's not widespread use. I always say to people, you know, the old-fashioned expression, you know, an ounce of prevention is worth a pound of cure. Make sure it's available, and you can do a lot of these searches yourself without going to a lawyer. So when I first speak with clients about availability, usually their marketing department, or if it's a single owner, has bandied about a number of options. We'll do here what we call preliminary direct hit searches. So we'll look at and see whether or not anybody has anything identical, and whether or not it's just a straight up no, go back to the drawing board, pick something else. So, you know, it's really important to make sure it's available. So you can do some stuff, an internet search, a Google search, by simply putting in your trademark and seeing whether or not there's use by others. You can narrow that down by putting in, you know, Scotiabank Financial, so that it's a basic description of your services along with your trademark to narrow down who's using it in your field. Because you want to make sure there's no prior use out there by other people, because that can affect your rights, both in terms of common law rights and in terms of your registration. So the other thing you can do, in addition to the internet search, is have a look at the Canadian Intellectual Property Office and the US Patent and Trademark Office trademarks databases. So if you just type the acronym CIPO or Canadian Intellectual Property Office or USPTO into any search engine, these searchable databases will come up, and they're user-friendly, so you can get an idea. It's not a comprehensive search. You have to understand how to use their searchable database tools to get a good comprehensive search. But, you know, for the most part, we're just in this first step, you know, initial looking at whether or not, you know, this is a no. And you should go back to the drawing board and look at another brand. So use them. You know, in upcoming slides, I'm going to show you what those web pages look like. The other thing you want to do really quickly is, you know, ensure that you can have the related domain name. And in the slide, I've used the singular here, but domain names, the basic ones, the .com, the .ca, .org, .biz, are all, you know, essential. Have a look at who's got what and what's available. So this is what the Canadian Intellectual Property Office trademarks database looks like. And if, you know, you can select a search field here and you can enter. So trademark lookup will be one of your options. Put in your trademark and have a look at what comes up. It's important to look at, you know, for example, if we are searching startup zone and the result, there's 4 results for startup zone, and you think, okay, how can there be 4? But there can be, but they're all for very different products and services, so they wouldn't be considered confusing. So, you know, it would be the same thing if I searched for Kodak in association with cameras. Someone else may have Kodak in association with toilet paper, completely unrelated, so the Trademarks Office may let them coexist. So have a look at if you get results, have a look at what those results show. The same thing you can do on the USPTO trademarks database, just give you an idea. Because if your goods and services are internet based, you also want to know what's going on in the US, whether or not you ever intend to carry on business there or use, you know, use the internet to provide your services. It's still good to know what's going on in the US. So, you know, your initial searches show a similar trademark is being used for similar products and services or similar businesses. What do? Option A, develop a different brand. Option B, seek legal advice on the registrability of the trademark you wish to use. So most people, for cost reasons, choose to go back to their own drawing board, pick another brand, and do the same searches again. Sometimes people will get wedded to a trademark and think we're different from those prior trademarks for all these reasons. You know, talk to a lawyer, you know, have a more comprehensive search done, and maybe there's a chance or a shot at this trademark. So the other, you know, the other scenario here is that, let's say you do these searches, Google searches, and you've looked at the CIPO database, you've looked at the US database, and there's not really any results, and certainly nothing of concern. So, you know, what's your next step? In my view, your next step is a comprehensive search, because the Trademarks Office is only going to let you have trademarks that are not confusingly similar from others. In other words, identical is not the test. Confusingly similar is the test. I'll often have people say to me, Well, what if I add the in front of it? So instead of startup zone, I'm the startup zone. They're still confusingly similar. So these comprehensive trademark searches done by trademark searchers will give you a really good idea about whether or not your trademark is registrable. The cost for a comprehensive trademark search in Canada is $950 per trademark searched. They do a full comprehensive search of the Canadian database. They do a common law internet search, and they do a nuanced search which looks at trade names or business names that have been registered by other parties, and they give an opinion on whether or not it's registrable. We don't do them. We farm that out to a trademark searcher we've been using for about 15 years. He's great. So that's that. Then you'll get folks who, and this slide comes from a presentation I did to a client, marketing department, and the client wanted me to put this in, and so I was going to take it out today, and then I thought, you know what, I'm going to put it in because, you know, it's the doom and gloom lawyer response. So if you don't do any searches, if you don't look at what's out there, and you just proceed to launch and use the brand anyway, you know, the real potential consequences here is that the trademark owner will commence infringement proceedings against you. Or if you apply without doing the proper searches, they'll oppose your trademark registration during the application process. You know, and even after you get, let's say you apply for a trademark registration, you get it, but you never did your searches, and, you know, there's a company out in Saskatchewan who's using Prairie Startup Zone and has been using Prairie Startup Zone for 15 years before you, and you find out about their use. You can't enforce your registered trademark against them because they have prior use, and that's their defense. They could also get aggressive and apply to invalidate your trademark registration based on their prior use. So I put in the scary slide just to give people a heads up about how important it is to do your due diligence and know what you're getting into. I have some clients who, you know, despite the prior use, decide that this is their trademark, this is their brand, they're wedded to it, they want to pursue it, but they know the risks going in, and they would never take action against that prior user. So they would enforce against everybody else except the prior user. So, you know, that's another practical way to deal with all of this. So I'm talking a lot. 12:29. We need more time for questions. So I'll move this along. So if your comprehensive search is clear, you know, I would say first get a domain name registration. We don't do those anymore because it's so cheap and easy for clients to do them themselves. But I recommend, you know, if this is your main brand, to get all the basic domain names registered. You know, there's a list on the screen of the type of information you'll need for a trademark application. So you want to register your trademark. So you have to decide who's going to own it. And if that's a company, then the full legal corporate name, address is required. If you use this as a sole proprietor for some time and then you incorporate it, you get to claim, you know, you get to claim the benefits of the use by you when you were a sole proprietor. And so in the application, we would list not only the current owner, the corporation, but also the prior sole proprietor. You have to identify the trademark. So is it a word? Is it a design? Is there color being claimed as a feature of the mark? So, you know, a lot of times I'll have someone come to see me. And so if we go back to the initial slide where I showed you the trademark. So startup zone, I have a lot of larger corporate clients who will come to me and say, you know, we want to trademark this. And I'll say, okay, are you using Startup Zone on its own, or is it always used in this logo? So Startup Zone is used as a word on its own. It's used in this logo format, and it also has some color in it. So my super cautious large corporate clients will say, apply for all three. So they'll ask me to apply for the word mark, Startup Zone, just the words. They'll ask me to apply for the logo as you see it on the screen, but in black and white. And then they'll ask me to apply for the logo in the screen with color claimed as the feature of the mark being the green O. You know, most people can't afford to do that. So I always recommend, if it's a distinctive word mark, in other words, if it's not just a descriptive word, I recommend that if you've only got one application to file, or the budget for one application, that you file for the word mark, because it provides the broadest scope of protection. And you can apply for the logo later, or simply when you've got the budget to do so. So if you are applying for a logo, you need to provide your trademark agent or the Trademarks Office with an electronic copy of the logo. The Trademarks Office is still operating like it's 1970. So you have to provide a copy of your logo in TIFF format. In Canada, it's JPEG. It has to be less than 1 megabyte. And you have to provide a list of products and services that you're using the trademark for, or you intend to use the trademark for over the next couple of years. So these are the basics information that you can talk to your trademark agent about in terms of putting the application together. But I just note that there were changes to the Canadian Trademarks Act in June of 2019 that were significant. It's the first time the act has been changed in many, many years. A couple of years ago, from start to finish, it took about 18 months to get a trademark registered. Now I've got trademark applications that I filed in May of 2018, and they still haven't been examined by the Trademarks Office yet. So there's a backlog. One of the big changes to the Act was that you no longer have to prove use of the trademark to the Trademarks Office prior to registration. That's new and it's big. It doesn't mean that you don't have to use the trademark. You do. If you're going to enforce it for the trademark to be valid, ultimately, you still have to use it. This change was made so that it was less work to get a trademark registration, and it also allowed for a cleaner trademark application process. But we'll see in the end whether or not that happens. So what's happened, practically speaking, is the timeline to get a trademark registration is out of control. Right now, I'd say it's 2.5+ years. There's a huge backlog. There's a number of reasons for that. With the June 2019 amendments, the amount of trademark applications quintupled because you now have what we call trademark trolls applying for trademarks because they don't have to prove use. So they're just making all kinds of applications and then trying to sell them to the actual entity that's using the trademark. So you've got a huge backlog of applications now that's causing these time delays. The other problem is that the Trademarks Office communicates by mail other than the initial filing and the registration fee at the end. So I can file your trademark application online, but the entire prosecution of the trademark application takes place by mail, not email, I can do fax. It's kind of crazy between myself and the Trademarks office. And then COVID has also added some further delays. Renewal. So you've got the trademark registration. Unlike the US, in Canada, you don't have to maintain your trademark. You just have to renew it every 10 years. And again, you can renew for as many 10-year periods as you wish. As I note on the slide, you do have to continue to use it, even though it's registered. So, you know, some people think, okay, I've got it registered, I'm safe, whatever. You have to continue to use it for it to continue to be a valid trademark registration. So throughout, I've been talking about the importance of use. It's important everywhere, whether you're doing a search, you know, and looking at people who have prior use over you for a similar trademark for similar goods and services. It's important in terms of the application process. So if someone has filed an application prior to you, it's going to get cited against you by the Trademarks Office. You know, it's important that you continue to use it so that you can maintain your trademark registration for enforcement against others, and so that you can renew it. So really, you know, I'm reading from the slide here, but it sort of summarizes it to say, use determines who gets the trademark, who keeps the trademark, who can enforce the trademark, and who gets sued for trademark infringement. So the colloquial phrase we often use with trademarks is use it or lose it. I often get questions on this, so it's my final slide and I'm over by 7 minutes. When do I use the TM and when do I use the R in the circle? So you can use the TM symbol for an unregistered trademark. So as long as you're using it as a trademark, you can use the TM. So if this is something you're using in association with your products and services as a brand, then you can use the TM. You can only use the R in the circle once you've registered it. And that can be in any country, as long as it's a valid representation. Licensee marketing. So for those of you who have gotten successful enough that you own the trademark and you're going to allow others to use it under certain terms and conditions, there's a bunch of marking that a licensee has to do to ensure that the public knows that they are not the owner of the trademark, but they are using it under license. So my apologies. I went on and on for quite a while, so longer than I had thought. So any questions?
Donna, if you want to, you can stop screen sharing now and we could go into gallery view. That way, if people want to show their faces, they can.
Okay. So I'm going to do stop share.
Yeah. All right, sweet. Only a few of us with our cameras on right now. But yeah, if there are any more questions for Donna, I know we do have a few in the chat from Jacinth. If you want to check those out, Donna, if you can see the chat. And then we can kind of go through everyone who's here now.
I'm working on registering a trade name. What is the difference with a trademark is the first question. So this is common. So people will say, I have a business name registration at PEI corporations or New Brunswick corporations or Nova Scotia corporations. So why do I need a trademark? So the purpose of a business name registration or your corporation's name is for the public to be able to see what business they are dealing with and who is behind that business. So that's why it's important to register business names or corporate names. It is not an enforceable right. So you can't say, I have the business name for Startup Zone in PEI, and you know, I'm shutting you down because I have that business name registration. That's not an enforceable right. So you have to get the trademark to be able to enforce it against others. So that's the difference. The trademark is your brand. which sometimes can also be your corporate name. So if Startup Zone Inc. is your corporate name, but you're also using Startup Zone to provide your services, it's on your products, and you've got a logo, that's used as a trademark as well. But they're two different things and two different purposes. Okay. I'm having a hard time getting my trade name accepted. They say it's not precise enough. Who has the final word on this? Is it subjective to the agent assessing my request, or are there specific guidelines? So I assume this is a business name that you're trying to register with a local corporations registry. Ultimately, they make the decision. They now have a process whereby you can make arguments as to how it's not precise. I think what they're probably saying to you is it may be too descriptive. So if it's completely descriptive, if it's Canada's or Prince Edward Island's best law firm, then I suspect it's too descriptive and they want others in the jurisdiction to be able to say that they're the best law firm. So, you know, the final word is with the corporate registry, but there are guidelines and there are arguments that you can make. Since it's not in the trademark area, you know, I don't usually do them. One of the young corporate commercial associates sometimes does them here. Is there anything I should be aware of when navigating this myself? So I think that by that, I'm going to assume that you mean that you're going to apply for the trademark application yourself. If that's the case, usually the part of the problem here is the backlog. But the only time you get into an issue is if you don't properly fill out the application, in particular the description of wares or services, or you are filing for a completely descriptive trademark or one for which there is a prior trademark. So you file not having done searches or it's descriptive, it's going to sit in the queue now for 2 years or over unless they get their act together and get more efficient. So you're gonna apply, you're gonna wait 2 years to find out whether or not there are issues. And then if there are issues, it usually requires legal submissions to get to the next stage. So what I have found is that if somebody has a completely unique trademark for which there's no prior use and their goods and services are simple and limited. So let's say, use the example, you apply for Kodak in association with cameras, that's it. That can probably get through without, you know, you're probably able to navigate it yourself. Anything more complicated than that, and if you get into issues, it's difficult. You have to understand trademark applications, trademark law, and how to respond. So I know that doesn't answer that question directly. What rights do I have if someone is using a portion of my brand name? Well, if they're using enough of a portion that it's confusing with your brand, then, you know, if your brand is not registered, then you can send them a cease and desist letter based upon your common law rights. But it has to be confusingly similar. That's the test. So whether or not, you know, a casual consumer walking along would see that portion of your brand name being used by somebody else and be confused and think it was you. So that's really the basic test. If that answer is yes, then, you know, you have, and assuming you've got prior use for similar goods and services, you know, you could send them a letter saying, please cease and desist And you could enforce it in the geographical area in which you've built up a goodwill. If your brand is not registered. If it's registered, then you can send a cease and desist letter regardless of where they are in Canada. Okay, that seems to be it for the written questions. Anybody have any verbal questions?
I do. It's Jelaine from Fresh Start Fromage.
Hi.
Hi, how are you?
I'm doing great, thanks. How are you?
Good, great. I've got all the information I need, sort of. So I just want to clarify something you said earlier about simplifying. So I have Fresh Start Fromage, and then I have a tagline, and that so I'm just clarifying. So that would be a completely different process for me, right?
Yeah. So each application. So mostly you'd have I'll use the example of you'd have McDonald's is your main brand, and McChicken would be one of your sub-trademark, would be another trademark, another application. I'm trying to think of their famous slogan.
It would be over 1 billion served or something like that.
I think like a slogan that wouldn't be because it's factual, right?
Okay.
So I'm loving it. Is that the trademarks for the?
Sure.
I think it's I'm loving it. So I'm loving it would be their slogan, and that would be a separate trademark application. So they'd have a trademark for McDonald's. They'd have a trademark for the Golden Arches. They'd also have a trademark that combines McDonald's and the Golden Arches because they use it that way too, right? So it's important to apply or register your trademarks how you are using them, right? Because that can get you into trouble later too. So you should use it as registered, and if you're going to make a change, like sometimes marketing departments, or you'll go in a different direction, you have to make sure that it's still substantively the same. Otherwise, it's not enforceable. So if you're not using it as registered for the most part, that can get you into trouble as well.
And there's a company we use a tagline, Spread Love, and another company in Ontario started using it, but that's obviously I don't think they've trademarked it, but because we're on the East Coast, then I should just leave it as it is, I would imagine, instead of going through the whole process of that.
Well, if you register Spread the Love and you have prior use, you can, once registered, then you can shut them down. As long as their use is after yours and you have the registered right. Right. So that's the benefit of the registered right. That's a perfect example. So, Spread the Love, you're known in PEI, let's say even Atlantic Canada. This is going on in Ontario. So based on your common law, just using it unregistered, you can't enforce it against the guy in Ontario. However,
his products come here, or can I?
Yes, you can, as long as you have the prior use.
Right. Okay.
Okay.
Time period for prior use, like, do you have to be established for a certain amount of time? Do you have to prove that?
Yeah. Well, again, the longer you use it, the greater your rights. Right. But just if it's same product, same slogan, all it's going to take is who's the prior user, or if it's a first to file system. On the trademark registration side, which makes it a little bit confusing, but the first to file is who the trademarks office will give it to, but the person who's the first user can oppose your trademark application based on that first use.
Right.
So, so there's a famous Supreme Court of Canada decision that came out of the brick warehouse. So when the brick came into Canada many years ago, they applied for the trademark, the brick, in association with the sale of furniture. They got the registration and then found out about this mom and pop bricks furniture store in out west somewhere. And they had been using it for generations. And they tried to shut them down, and and were not successful due to the prior use. So, you know, so it's they got the registration. They had no idea of the existence of this company back, you know, back when they applied, because, you know, there would be no internet usage. There'd be no, so there's some prior use you may possibly never know about if it's a small organization that doesn't use the internet. So, you know, our searches are really limited by that.
Thank you.
You're welcome.
Hi Donna, I have a question for you.
Hi, how are you?
I'm doing good, and apologies for showing up to the call a little late. I had it plugged into my calendar at the wrong time, and only discovered.
No worries. It was a little dull, so you're getting a lot of information from the questions.
So I apologize in advance if you covered this earlier on in the presentation. But a big question that I get is around what the practical risks are associated with sort of not going through the trademark process. Right? So you've created a brand, you've registered the URL, so you've captured the website, you've captured the Twitter handle, and you have all of the things that are associated with that name mark that would be practically used for business services. So if somebody wanted to take that and set up their own website with that sort of URL, with a few changes that it'd be difficult for them to do that. What sort of advice would you have for anybody that would be sort of thinking down that path of like, I don't need to go through the trademark process because I've got the website, I've got the Facebook page thing, I've got the Twitter and Instagram handles. That's what's really going to protect me from somebody coming in and stealing my brand.
It's not. So none of those rights are enforceable against others. So that's the big key. So we talked earlier today about two types of trademarks. So business name registrations or corporate name registrations aren't enforceable either. So the only thing that will allow you to shut down others or to defend yourself by waiving your trademark registration at them is either, you know, your common law trademark rights. So you have certain rights that arise just by using the brand day to day in association with your goods and services, you know, on your packaging, in your advertising. So, but it only extends to the area in which you've built up a goodwill or a reputation. So if that's PEI, then you can only enforce it in PEI. If you register it, it doesn't matter where you're using it, you can enforce it Canada-wide. So you can stop others from using it. The other thing I've noticed on a really practical level is that you will often have people, you know, blatantly ripping off trademarks, trade names, logos, artwork, graphics from websites. But a lot of times, if they go check on the Canadian Intellectual Property Office Trademarks Registry and see that you've gone to the trouble of registering it, there's a deterrence there in some cases. You know, the certain rip-off artists will just go do it, but it does add a little bit of deterrence. But really, it's both a sword and a shield if you've got it, and those other things are not enforceable. And even within the social media platform, so let's say, you know, you're putting it through the Facebook admin folks and their processes to say, you know, Buddy's using this of mine, shut them down. Even within those processes, they want to know if you have a trademark, in particular, whether or not you've got a registered trademark. So, you know, on Amazon, the processes are like, oftentimes I get, for clients, I'm often getting emails from Amazon saying, you're the authorized representative, please confirm the ownership of this trademark, right? And a lot of times they don't even care which country, but, you know, they want the trademark as evidence to determine ultimately who has the rights. So if you want to enforce your brand, and then you also want, you know, you don't want someone coming to say you're infringing, say, I got my trademark registration. So it comes down to what's enforceable and what's not.
Awesome. Great. Thank you.
Does that help? Does that answer the question?
Yeah, it did.
Okay. Anybody else? Oh, I didn't even look. I don't think. No, I think we're good.
Awesome. Yeah, I don't think we have anything else. So yeah, Donna, I don't know if you have a few last words. If people have questions after this, kind of where do they go, and at what point should they be seeking legal support for these questions? But yeah, overall, I think it was really helpful.
Oh, good. I'm glad everybody put up with my COVID hair, so this is good. So, you know, you can do a lot of the background stuff yourself. So those searches, like, you know, common law searches, look and see who's doing what in your area on the internet. Go on the Canadian Intellectual Property Office and the US Trademarks Office, Trademarks databases. Have a look at what's there and don't bother. If someone's got a registered trademark that's confusingly similar to yours, not just identical, but confusing, then go back to the drawing board, because you're going to spend a bunch of money on marketing materials, you know, getting ramped up, and then only to find out you're going to spend money on someone like Donna MacEwan to defend a trademark infringement action, to, you know, and most of the time when someone sends you a cease and desist letter, they just want you to stop, right? But that's expensive too. They're not looking for money. They just want you to get rid of your inventory, get rid of your promotional materials, take it off your website. But that costs money and time. And it also, you're stuck with losing a brand that you had built up a reputation with, right? So now you've got to reintroduce your brand. So just do all that due diligence up front. Come see me if you see problems, but you want to know how big a problem it is. You know, if, you know, some people will apply for a trademark application on their own. If it's complicated, if you have a lot of goods and services, and there's a, you know, trademark that you think is similar, but you're going to give it a shot anyway, I'd go see a lawyer first. That's when I'd go see a lawyer. But yeah, we're here. I'm in the Charlottetown office. I did practice in the New Brunswick office as well, in the Moncton office as well. So I'm here on Kent Street, and happy to help if anybody needs me. And that's it. Thank you for having me. It's been great.
Awesome. Thanks a lot, Donna. And we're actually going to have Donna back in 2 weeks' time to talk a bit about IP agreements. So if you guys want to just follow along on our website and social media, you'll see that posted soon. But yeah, looking forward to it. Thanks, Donna.
You're most welcome.